I'm Chris Farrell, and this is On Watch. Welcome, everybody, to On Watch, the Judicial Watch podcast, where we take a deep dive behind the headlines to give you information that the mainstream media just simply won't. We also make an effort to uncover some lost history and to try to explain the inexplicable. Today, we've got a real treat for you. We have Judicial Watch attorney Michael Bekesha, the man who litigated the Clinton sock drawer case, a case that all of you will become familiar with one way or another over the next few months. And we'll get to the details of that case and how it all played out. But first, I want to ask you to please subscribe to our podcast, whether you're watching us on YouTube or listening on one of the podcast platforms, Spotify, etc. Please subscribe, leave us a rating, a comment, email us, let us know what you think or what you'd like us to dig into. And we really appreciate you taking the time to watch and to listen. So joining us today is my friend and colleague, Michael Bekesha, attorney with Judicial Watch. Michael, you are the man. You are the man that litigated the Clinton sock drawer case.
Yeah, I appreciate you having me on to talk about one of my losses.
Yeah, no one likes losses. But if you're going to lose a case, this is a great case to lose, at least because of the decision, because of what came out of it. And I always say no one wants to talk about losses, but this is a good one to lose. So for those people who are attention deficit constrained, if you were to give a quick overview, a 2-minute description of what the whole Clinton sock drawer case is about, why is it relevant? Why should people care about it?
Yeah, so the Clinton sock drawer case, President Trump refers to it as the Clinton socks case. So it's the same thing. He forgets the drawer, but Clinton socks is a little bit catchier.
Sure.
While he was president, President Clinton created audio tapes with a historian, little over roughly 79 or so tapes. On these tapes was President Clinton being president. He would take phone calls with members of Congress.
Right.
He would talk to foreign leaders. He would ask policy positions. Recently, the historian author Taylor Branch
right.
Gave an interview with the Daily Caller and said, oh yeah, some of the stuff was, pretty high-level stuff.
I'm sure it's classified material. It had to be.
It was. Osama bin Laden and cruise missiles was something that was discussed on the tape, something that surely was classified at that time. And so they had these conversations in the White House. The conversations were set up by the White House operations officers. The tapes were subsequently kept in the White House during Clinton's tenure. And when Clinton left office, he took the tapes with him. Taylor Branch eventually wrote a book. We read the book. We saw what he talked about on these tapes in the book. And we said, wait a second. These things sound like presidential records.
Mm-hmm.
So, being Judicial Watch, what did we do? We sent a FOIA request.
Right.
And we got an answer where archives said, well, we don't think these are presidential records, so you don't get them.
And we sued.
We sued because, that's what I do. And we were in federal court here in Washington, D.C., and we made the argument there's presidential, official government information on these tapes. These tapes should be made available to the public because it would be fascinating to hear President Clinton talking about what he was doing on a daily basis.
Especially since Taylor Branch had already taken the material and written a book about it.
Absolutely.
Right? So.
Absolutely. But, hearing the real words of the president.
Sure.
Taylor Branch, what he did was he apparently went into his car after each interview and wrote down everything he remembered, because he didn't actually have the tapes when he was writing the books.
I see.
So we really wanted the firsthand, the actual tapes, President Clinton being president, making presidential decisions, having presidential conversations. We wanted that information. Justice Department or archives said no. Justice Department came in. Justice Department was defending archives. The Justice Department attorney in the case said, those aren't presidential records. And even if they were presidential records, it doesn't matter. The President of the United States decided they were personal records, took it with him when he left office, and there's nothing the government can do about it. That was the position of the Justice Department in 2010. The federal court, the judge, Amy Berman Jackson of the District Court in D.C., agreed with the government. She said that under the Presidential Records Act, the president has the sole authority to designate what is personal and what is presidential.
That sounds very interesting. And then also, I guess the second part of that was that nobody can second guess the president.
That's correct. Once the decision is made, once the president has left office, end of story.
So somebody at the archives can't say, hey, wait a minute, I think you might have something. Or somebody in Congress, some committee of Congress can't come in and say, oh, no, we believe you should give us X, Y, and Z.
That's correct. And the reason the Presidential Records Act is set up like that, because from a policy standpoint, that doesn't really make sense, right? Because you would want the records of the president to be preserved. If somebody, had records that you thought were presidential, had historical value, you would think archives should be able to go get it down the road. However, we have separation of powers.
Right.
We have the Constitution that gives the executive the authority to do what the president wants with his records, with his office. And Congress can't come in and interfere with that and micromanage how he's handling his records.
So this is very important stuff. That's sort of the fast, not even fast, that's that's a great explanation that most people have no real comprehension of or understanding of the circumstances. Now, you wrote an excellent Wall Street Journal opinion piece, editorial, based upon your experience litigating this case.
Yeah, everybody wants to hear from somebody that loses.
When did that Wall Street Journal article, when was that published, do you recall?
That was probably about 2 months ago.
Okay, so what was the reaction that you got from friends, colleagues, not so friends? What was the interaction or the feedback you received?
Friends, colleagues, people I haven't spoken to in 20 years.
Suddenly,
you get a text message, you get an email, sometimes a phone call.
Yeah.
Was very favorable. People were fascinated. They were interested in, this intersection of the Presidential Records Act, my involvement, was I defending President Trump? Am I going to be his lawyer?
Right.
Am I auditioning to be his attorney general in the next administration? You get all sorts of
which you can
questions.
neither confirm nor deny.
That's the way Washington works. That is true. So you get all these questions, but then you also get a lot of hate mail.
Yeah, I bet.
And then you can go down the rabbit hole of reading the comments online.
Don't ever read the comments.
But then also, curiously, the National Review online seemed to take offense to my article and seemed to mock it and trash it a little bit.
Because they're such wonderful experts, having litigated the case in front of a federal court. They know far better, right?
Everybody that thinks they're a lawyer or wants to play lawyer on TV has views, and they want to share them.
My condolences on that entire experience.
Even former Attorney General Bill Barr got in and said it was a nonsense of an argument.
It seems to be exactly on point. You had a president who decided what he wanted to take and what he didn't want to take, and then a court came in and said he had the authority to do it. So I think it's very relevant.
It is. And, a lot of people got hung up on this idea of agency records. So the Presidential Records Act explicitly says it doesn't cover agency records. And, a lot of my critics were saying, well, these weren't records of the president. They were, Department of Defense records or CIA records or, records of these agencies that were provided to the president. That may be true, but that doesn't actually make them agency records.
Not when they're in the custody of the chief executive of the United States.
Right. So they're two pieces. And we know this because we sue a lot.
That's
and we
correct.
litigate a lot. And, I hate saying we lose a lot because we are fighting, we are bringing issues to the court for the first time.
Right.
Issues that the courts don't address. And we're pushing the envelope to bring transparency, to hold politicians in account. And, a lot of the time, the courts don't want to go there.
Let me put it this way. the courts, in my experience, having been watching this for only 24 years here at Judicial Watch, is that the courts are enormously deferential to the position of the Justice Department or the agency justice is representing. So if the Department of Defense says, oh, no, we know that the whole world is aware of something and they're all discussing something and there's been public statements and everything else, we still say this is classified. And so there's a sort of like, I don't know, it's probably not accurate to say like a wink and a nod, but there's a sort of, well, we know that everybody knows this anyway, but the agency or the Justice Department says no, and so we have to rely on their representation, so we're just going to say okay. And courts do that over and over and over again.
They do. So there was this other case where we sought the visitor logs from the Secret Service.
White House visitor logs, these are very important. Way back in the Clinton era, we sued very successfully. It was called WAVES. It was the White House, the Workers and Visitors Entry System is how these records were set up. Bush administration changed it and made them unfoyable. Anyway. Tell your story.
Yeah, so during the Obama administration, we sought the records again, and we argued the case up at the D.C. Circuit. And the D.C. Circuit at that time, we had a 3-judge panel, and one of the judges and the one that ruled on the case, wrote the opinion, was Judge Garland, who now is Attorney General.
That seems to ring a bell.
Our now Attorney General in charge of the Justice Department, putting forth the positions related to Trump and his records. And in that case, Judge Garland said that records created for the president by agencies are not agency records. And so, again, looking at the facts of the indictment against President Trump, what the records appear that he had in his possession were records that were created for him by the agencies. A lot of them are his daily presidential briefing.
Right.
And so those records are not agency records, even though they were created by the agency. Then Judge Garland said, no, if they were prepared for the president, they are
Here's
presidential records.
Here's the other dirty little secret about all classified records, and that the entire record classification system of the intelligence community is all built on the idea of the classified documents are produced in order to assist the executive in making decisions. So we're protecting this information because it's so special, it's so unique, it's so sensitive. Why? Well, so that ultimately the president, the chief executive, can make decisions based upon this very valuable, sensitive information. That's the reason why we have classified information. And so, even if an agency produced it and it's their product and, it signals intelligence, so the NSA says, oh no, that's ours. The only reason they're operating, the only reason they're generating this material is for the executive to make decisions. It's his material.
And that's because of that, that important document, the Constitution, that says he's the commander-in-chief, right?
Right.
I mean, the president is in charge of our military. Right. He's commander-in-chief. He can do what he wants.
So I did something radical. I went back and I actually read the court transcript of your argument in front of Judge Amy Berman Jackson. And so she's going back and forth with you, and she essentially says, well, what do you want me to do? And you're trying to encourage her to make the right decision and to go ahead and get the records or documents. My reading and and I remember being in the courtroom, but my sixth sense on all this is that she was almost baiting you into saying, well, send the marshals out and seize the tapes. I mean, that was the direction that she was going. She seemed to be, come on, Michael, go ahead and say this, because doing such a thing would have been off the charts extraordinary, correct?
Yeah, because that was 12 years ago, 13 years ago. Times apparently have changed.
Right. So, I mean, in hindsight, reading it, really, that's the takeaway from me is the notion that anyone would request that law enforcement, whether it's the U.S. Marshal Service, acting at the direction of a federal judge or any law enforcement, would go out to a former president and seize records, documents, any item, was unimaginable. It wasn't the regular process. It wasn't the sort of the deference paid to a former chief executive. And it's remarkable to see the Clintonian sort of mindset and thinking, and the court's deference, and now this extraordinarily aggressive, adversarial, hostile treatment of how Trump was. I mean, it's night and day.
It is. And, the other thing that my critics would say is, the indictment doesn't talk about the Presidential Records Act. It only talks about the Espionage Act.
And that's part of the problem.
It is part of the problem. But the Espionage Act, people need to remember, talks about whether or not the person in possession of the records is authorized to be in possession of their records. And so there's an intersection with the Presidential Records Act that no one is talking about, which is President Trump, as a former president, authorized to have the records that he has in his possession? And the argument goes, when he's president, he collects records. Records are given to him.
All the time.
He gets to decide what records are presidential, what records are personal. Do they go in box A and box B? According to the indictment, so not even, speculating, but reading the actual indictment that was filed against the president, it says he received documents, he placed them in boxes. I think that's paragraph 2. I believe paragraph 3 or paragraph 4 says when he left office at 12:01 on January 20th,
right,
he took those boxes with him. So what does that mean? Under the Presidential Records Act, he designated records that he was going to keep, and he took those records when he left. He was authorized to do so. So is he authorized to have those records?
Presidential Record Act says he is.
The Presidential Records Act seems to suggest he is. And then, everybody makes fun of him because he said, well, I could just declassify things by thinking about it. Well, he's not that far off.
No, in fact, he's not off at all. I mean, I know that's sort of, people look at that and I think it's a flippant comment or just sort of, but actually what he's saying, the essence, it's kind of like when he said, Obama wiretapped me.
Yeah.
That's a shorthand way of actually describing what was done to him, but it's articulated in a way that is very condensed and sort of summary and doesn't give the full explanation. But the essence of what he's saying is true.
It is, because while he was president, he could show any classified information, any top secret information to whoever he wanted. He had that authority. And so he had the authority to do what he wanted with that record when he was president. So when he was president, he could make the decision to authorize his future non-presidential self to have control of that record. And there's nothing in the indictment that says he didn't do that.
Just for a moment, I'll remind or maybe inform our viewers and listeners that very famously, Jimmy Carter, in a speech in Miami, got up and talked about the National Reconnaissance Office and our abilities through satellite technology to collect intelligence, both imagery intelligence, signals intelligence. When he did that, he just got up and said it. No one had ever discussed that satellite capability before. And he had made the decision that he was going to make it a public statement, sort of a muscle flexing effort to show, hey, look, we can see and hear things that you don't think we can. So that was his decision as commander-in-chief. Nobody approved it. He just did it. Why? Because he could. And it caused enormous uproar in the intelligence community because people's feathers were ruffled that he just decided to do it unilaterally. But that's what he can do because he's president. So, going forward, I think it's remarkable that the indictment against President Trump doesn't mention the Presidential Records Act at all. To me, it's sort of a conspicuous absence. It screams, there should have, in my view, if he was really kind of dotting the I's and crossing the T's, there would have been a passing reference as to why it doesn't matter, or why these circumstances are so extraordinary that they moot out anything in the Presidential Records Act. They don't make that argument.
They don't. And everybody needs to remember that indictments are just allegations. They're not facts. It's not proof. President Trump's lawyers are going to have the opportunity to challenge the indictment in court. The government can put their position, forward. So we're going to learn a lot more about what the government and what President Trump thinks about the Presidential Records Act.
Yep.
It'll be interesting to see if now Attorney General Garland's Justice Department takes a different position from then Judge Garland took. It'll be interesting to see if the Justice Department takes a different position than it took
for the last 13 years.
For the last 13 years.
Yeah.
And, I'm curious to see if President Trump's lawyers will agree with me and argue what I do in the Wall Street Journal.
Yeah, maybe you'll be called as an expert witness.
Put under a microscope again. I don't know if this is enough pressure.
Well, here's a case where, you don't know what you know, or things kind of play themselves out in an unexpected fashion. And I don't think anybody 13 years ago on the Clinton sock drawer case, I know we left kind of frustrated and like, oh, well, we took a shot at it. We tried to recover the information, but little did we ever realize that case would feature the way that it does now. Before we wrap, any last comments or thoughts about the whole saga of the Clinton sock drawer case?
No, just going to your point there, you've been here 24 years.
That's all.
I'm at 14 years, so I'm catching up to you. And it's amazing that over this time, the amount of cases we've litigated and things that we've seen over the years keep popping up. And they keep popping up in different ways. And I think that's why Judicial Watch is so good at what we do, why we're so strong, and why it's so important that we keep doing our work, because you never know how our experience is going to play out in the future.
Yeah.
I really didn't know at that time that, the questions that Amy Berman Jackson were asking me about, well, how would we go about getting records from President Clinton would be playing out at the FBI and at the senior levels of the Justice Department 13 years later.
And I like to remind folks that when you look at the volume of work that Judicial Watch does in open records, both requests and litigation, Syracuse University has an outside organization called TRAC, Transactional Record something or other Center. I forget the exact acronym. But what they do is they look at who's out there using FOIA and other state open records laws. And I think it's important for people to understand the volume, not just the volume, but the depth of what we're doing. No one does more FOIA requests than Judicial Watch. No one litigates more than Judicial Watch. In fact, the next three requesters and litigators combined don't equal what we do. And among those are people would think, oh, they must do a lot of work in this area, like the American Civil Liberties Union, right? ACLU is a big operation. So the next three combined don't equal what we're doing either on the requester side, just trying to get information and then reviewing and processing documents, or the times when we decide that we have to fight over it. And you and your colleagues go into court and litigate and use the legal process, the court, to pressure these agencies into turning over records. And so, I'm very proud of that. That's something I think as an organization that really puts us in a position where we're doing more than anyone else to try to get these records. Why are we to get these records? Well, because we want to educate the public about the operations of government. We want to be able to have a conversation about this. Someone just raided the former president's house. Well, hold on a second. We have experience in this. We've gone through this process from the initial request through to your arguments in front of the judge through the order. This is all, it seems like it's obscure history, but guess what? All of a sudden, it matters very much.
You never know when it's going to matter.
Exactly. So, Michael Bekesha, thank you very much for your time and efforts 12 years ago, 13 years ago, and today. We appreciate it very much.
Thank you. Have me back when I win a case next time.
We will. Next time there's a big win, we'll have you come in and we'll discuss it in excruciating detail.
Excellent.
I'm Chris Farrell, on Watch.